Caregiving can sometimes feel like an impossible struggle. Caregivers may be torn between taking care of loved ones and trying to maintain balance in life. The good news is that it doesn't have to be that way. The Caring Generation with host Pamela D. Wilson is here to focus on the conversation of caring. You're not alone. In fact, you're in exactly the right place to share stories and learn tips and resources to help you and your loved ones. So now, please welcome the host of The Caring Generation, Pamela D. Wilson.
I'm Pamela D. Wilson, caregiving expert witness, consultant, and guardian of the Caring Generation. Thank you for joining me for this week's show, episode 239, Legal Risks in Eldercare. What happens when adult children manage healthcare decisions for parents? As always, we'll take a look at this issue from both sides. The risks for adult children and the risks for aging parents, because it's important to identify information that you may not consider if you don't have previous experience with power of attorney documents or being a power of attorney agent. On this point, I'll share heart-wrenching situations that you can prevent once you realize the unexpected things that can and will happen. I'll start by setting the stage for this discussion by giving context, which is background information about fiduciary duty in the context of healthcare decision-making as a durable power of attorney agent. Understanding this can help you be at opposite sides. My goal is to have parents and children who are caregivers work together instead of against each other. Then I'll briefly explain how the actions of fiduciaries can cause problems. So if you are an agent, you can prevent yourself from doing things that could get you into a lot of trouble. I'll also give real-life examples of what can happen when the emotions of adult children, who are the power of attorney agent, can take priority over fiduciary responsibilities, and how poor decisions can turn into disastrous and unexpected care situations. I'll start here and then take a step backward. One example is an adult child, a medical power of attorney agent, who's visiting a parent in their home and they witness a fall. Mom can't get up off the floor, and the daughter doesn't have the physical strength to lift mom. So the daughter calls 911 for a lift assist. The paramedics come and they get mom up off the floor and they put her in a chair. 911, though, wants to be cautious. And they say, well, we should take your mom to the emergency room just so she can be checked out. We want to make sure she hasn't broken any bones and that there isn't anything else going on. Well, the daughter refuses to allow mom to take 911 to the hospital. She signs the form saying, I refuse. It was just a silly fall. It's nothing. Next morning, the son calls mom, who says she's so tired she can't get out of bed. And she mentions her fall the prior day saying, I just don't feel right. The son, concerned, calls 911. The hospital emergency room calls the son, tells him that mom has a hip fracture, a urinary tract infection, and pneumonia. So in this case, the daughter's decision to refuse to have mom checked out at the emergency room the day before, it was a bad decision that can have very serious consequences for mom's ability to recover now that she has 2 infections and a broken hip. The son, who hasn't yet spoken to the daughter, is co-power of attorney agent for healthcare. And you can bet he's going to have a lot to say. We'll talk about more later about how this might play out. But how many of you have ever been in this position where a sibling, power of attorney or not, was not transparent with the family about a parent's health condition. If you've been in this position, I would love to hear from you. Please share a comment for this episode on your podcast app. Also, if you're a new listener, welcome. If you are a returning listener, thank you so much for listening again. Please help the Caring Generation podcast reach more listeners by subscribing to the show on your favorite app, leaving a comment, and sharing your feedback. Your likes, your follows, your comments, and your support helps other people all over the world find this podcast. I can't do that without your help. So let's back up for a couple of minutes so I can share two of the definitions I mentioned for the word fiduciary, and then we'll get back to more stories and the good stuff, which will make more sense when you understand the legal responsibility of a power of attorney agent and how agents, knowingly or unknowingly, get themselves into a lot of trouble. There are legal risks in elder care when adult children manage healthcare decisions. So, when one is a fiduciary, it's important to understand that these risks they're not one-sided. They're not what we would call polar opposites. The risks apply to the children and to the parents. What is a fiduciary? In simple terms, a fiduciary is a person who accepts a strict legal and ethical obligation to act in the best interests of the principal. The principal is defined as the person who creates the document, your mom or your dad. And they name you and one of your siblings as the agent. The fiduciary power of attorney agent is required to put the parent's needs above their own when managing financial and medical matters. This includes situations where a brother or a sister might be in denial about the seriousness of a health condition like Alzheimer's or dementia, and they allow mom and dad to do things that present a safety risk because they don't think mom or dad is that bad. I'll share an example of this coming up, so stay with me. Definition number 2. Let's define breach of fiduciary duty so that you know the issues that cause problems for agents. Number 1 is self-dealing, where a fiduciary profits personally at the principal or parent's expense. And I'll add context to this one because it's probably a little more complicated than it appears. So again, stay with me. Number 2 is failing to disclose competing personal interests. This is also known as having a conflict of interest. You may have heard about that. I'll explain more on that. Number 3, specific to healthcare, is violating the duty of care and loyalty, which can include misusing, sharing confidential information, or not sharing information. And in case you're wondering how I know about this, and I can talk about fiduciary duty and medical and financial power of attorney, from 2007 to 2018, so 11 years, I owned and operated a professional fiduciary company called the Care Navigator. I served as court-appointed guardian, conservator, medical power of attorney, financial power of attorney, personal rep of the estate, trustee, and a care manager. Today, I talk about this because I'm a caregiving expert, an expert witness, and a consultant all over the United States on breach of fiduciary responsibility, breach of standards of care and duty of care, negligence, elder abuse, and neglect. I also offer one-to-one counseling by telephone or virtual meeting. You can find more information about this on my website, PamelaDWilson.com. Now, let's talk about power of attorney. There are 2 types, medical and financial. There is a Uniform Power of Attorney Act that started back in 2006 that most states, with the exception of, so if you live in any of these states, your state has not adopted the Uniform Power of Attorney Act. Oregon, Arizona, Alaska, Minnesota, Missouri, Illinois, Louisiana, Florida, New York, New Jersey, Rhode Island, and Puerto Rico. All the other states, except these, as of the date of this podcast, are using that Uniform Power of Attorney Act, and I'll explain how that works. If you want to see more on this and states that may be in the process of adopting it, I'll put a link to the Uniform Power of Attorney Act on my website for this show. To get there, you'll go to PamelaDWilson.com, click on the Media tab, then the Caring Generation, and then scroll down and look for episode 239. The transcript is usually up a couple days after the show airs on podcast apps. But even with this Uniform Act, it's important to know that not every state puts a lot of effort into giving this free information to the public so that you can learn. So I want to applaud the groups in Colorado, like the Denver Bar Association Elder Law Section and others, for making this information available, because I'm going to use it as an example for the show. This information is really important for you so that you can understand the powers that you're giving to your children if you're a parent or a person creating a power of attorney document. It's also very important if you are the agent who is accepting these responsibilities, so you know exactly what you're agreeing to, exactly what you're getting yourself into. So the first topic on this that we'll discuss, because I'm asked this all the time, is about co-agents, which means two children being named as agents. Or in some cases, one child being named first and another child being named second, which is successor agents. So that's different from co-agents. But let's talk about the pros and cons for adult children and for parents of co-agents. So for this, I want to reference Colorado Statute 1514-711. You can look it up and you can compare it to a similar provision in your state Power of Attorney Act or statute. And so to make this easy, I just want to make it clear. I'm going to use elderly parent in place of principal and adult child in place of power of attorney agent, so I don't have to keep repeating myself. Colorado Statute 1514-711 says, co-agents are permitted to exercise authority independently. So the example that I gave you before, where daughter did not want to send mom to the hospital, son called the next morning, he sent mom to the emergency room, he found out her diagnosis. As a co-agent of healthcare power of attorney, he's permitted to do that. Now, if you're a parent naming children as co-agents and you don't think they will get along, you want to think of other options. A, you might not want to make co-agents. You might want to choose one child to be the primary agent and the other as a successor agent if the primary agent resigns or is removed. B, you might change the power of attorney document to say that your children cannot exercise authority independently, that they have to agree. If you're going to do that, though, you'll want to name someone who agrees to be the tiebreaker if your children can't or won't agree. This issue here is one of many, many, many family issues that attorneys drafting these documents do not think about, nor do they tell family members about, because these attorneys write documents. They are not the attorneys that end up in court battles when something goes wrong and you have to hire a litigator. Elder law, probate, estate planning attorneys, not all of these attorneys are litigators. And because of my experience for 11 years and ongoing today as a medical and financial power of attorney and working with medical and financial power of attorney agents, I know what goes wrong. I go serve as an expert witness in these court battles. I meet with older adults and adult children who are drafting their power of attorney documents today to talk about all of these things that can happen so that they can decide which ones they should take back to their attorneys, who can then write additional and appropriate language to address the concerns and the risks. So more on co-agents. Let's assume two adult children can make decisions without asking each other. This can be good if the adult child making decisions is following an elderly parent's direction, and the two co-agents trust each other and they communicate and are transparent. It can be a total disaster if one child makes bad decisions that harm an elderly parent and the other children who are not power of attorney are watching this happen. The Colorado statute also states that an agent who has knowledge of a breach of fiduciary duty by another agent must notify mom or dad if mom and dad doesn't know. And if mom or dad is incapacitated, meaning they have advanced dementia or Alzheimer's, then this sibling with the information has a duty to take action against the other sibling to safeguard the parent's best interests, which means that one sibling can take another sibling to court for cause and have them removed if there was a proven breach of duty or harm. So in the first example, let's say that the daughter just keeps refusing medical care for mom, and the son keeps calling mom, and mom has a hip fracture. She's got pneumonia. She's got a urinary tract infection. This happens multiple times. That brother has a duty to have his sister removed for cause, for not making good medical decisions that mom would have made to seek treatment. So, as you might imagine, these sibling power of attorney battles can get pretty nasty. And if they go to court, they can be extremely costly to a parent's estate, to the fact that they use up a lot of money intended for a parent's care. So if you are a parent and you know that something like this can happen in your family, you have to put a lot of safeguards in place to avoid it from happening. If you're a sibling who agrees to be a co-agent with another sibling, ask yourself these questions. Do you have the skills to navigate this type of knockdown, drag-out family conflict? How have you resolved family conflict with siblings and your parents in the past? Will you take steps to protect your mom or dad from a sibling who causes harm? Do you have the ability and will to do that? Or are you going to run the other direction? Being a power of attorney agent, it is a high stakes, high responsibility position when you're making decisions for a parent that can lead to litigation. If you're not up to these situations, it's better to say, no, I don't want to accept that responsibility, mom or dad. I'm just not up for this. Better that than you accepting it, your parent being harmed, and you doing absolutely nothing to help your parent. So if you're a parent naming your children, you got to ask yourself the question, what is the risk to you if this type of conflict happens? Two of your children become enraged at each other because one did something that wasn't reasonable and you were harmed. The potential of these battles are one reason that parents don't appoint their children to be a power of attorney agent and instead appoint a professional who won't be drawn into these emotional battles. I know this because for 11 years I was that professional, appointed by parents instead of their children, appointed by family members instead of their family members. I dealt with the cold, hard realities of doing what the principal wanted and making those decisions. And today, I help people sort through these conflicts, and I serve as an expert witness in court. So based on my personal experience as an expert witness and professional fiduciary, adult children disagreeing over power of attorney responsibilities, it's very common. Situations become even more complicated if or when a parent has dementia and can't speak up for themselves anymore. This is when those children who think they can get away with stuff, who refuse to follow a parent's previous wishes, who put their wishes over the parents' wishes, cause a lot of distress in families. This is even worse when adult children don't have positive or transparent relationships. and they have very different opinions about what they think should happen instead of doing what a parent put into writing or previously expressed verbally to all of their children. The legal risks in elder care when adult children mismanage healthcare decisions is harm to the parent. Parents, they think their kids will get along, and they may not be willing to acknowledge that they won't. Now, sometimes a parent's relationship with children is the reason their kids don't get along. One child was the favorite. The other child, who never launched, was allowed to become dependent on parents for money and a place to live. The middle kid, maybe they didn't get a lot of attention. Well, in these cases, a parent is harmed when they name the wrong child or the wrong children as agents, and they don't include these safeguard provisions in the power of attorney to protect themselves or even the children they name as power of attorney agents. Similar situations happen in second marriages all the time, when one spouse trusts the other spouse to do the right thing for their care, and that doesn't happen. Many times, the second marriage spouse is more interested in money and in property, maybe for their children, rather than their spouse's children. So, they stop the spouse's children from visiting, they end communication, they isolate their spouse. You've seen this play out with celebrities, Peter Falk, Glenn Campbell, and others in the news. Truly, all of these examples are heart-wrenching situations that do not have to happen. When you understand power of attorney documents, responsibilities, breaches of duty, what can go wrong, and plan so they don't. Number 2, other examples of potential breach of fiduciary duty and harm. A sibling purposely hides medical information about a parent having dementia because they're in denial about the degree of mom or dad's memory loss. Well, one day, dad gets behind the wheel of the car and he hits 3 people in a crosswalk. One dies. Your father and the 2 other people in the crosswalk seriously injured. But the hospital medical record and the doctor record shows a memory loss evaluation 6 months ago with low scores and a recommendation for the parent to immediately stop driving. Well, what happens? Your parent is sued for driving a vehicle while knowingly impaired and wrongful death. The sibling who was power of attorney agent who allowed the parent to continue to drive is sued for negligent entrustment for allowing a parent with dementia with a low score and also a parent who was told not to drive anymore. Number 3, let's look at one more common example. This one relates to my mention when previously discussing fiduciary breaches about self-dealing and conflict of interest. This can happen when children who are power of attorney move into a parent's home to live with them, move parents into their home to live with the children, or provide care or pay themselves without looking at how a power of attorney document is worded to see what's allowed and for direction on how all of this should work. So for this one, I'm going to compare a Colorado statute to an Iowa statute. Colorado statute is 1514-712. It's called Reimbursement and Compensation of Agent. The Iowa statute is Chapter 633, Be Like Boy, 112. Reimbursement and Compensation of Agent. The exact same subject, but totally opposite rules. Colorado says, unless the power of attorney otherwise provides, an agent is entitled to reimbursement of expenses reasonably incurred on behalf of the principal and to compensation that is reasonable under the circumstances. Iowa 633B 112 states, unless the power of attorney otherwise provides. An agent who is an individual is entitled to reimbursement of expenses reasonably incurred on behalf of the principal, but not to compensation. So, Colorado allows compensation of an agent. Iowa does not. So if you're in Iowa and you're paying yourself or you're doing anything as a power of attorney, time to stop and figure out how you're going to resolve that. But if you're in Iowa and your parents are drafting these documents or you're drafting these documents and you want to pay your power of attorney for acting as a power of attorney or maybe being a caregiver or managing care activities, you can do that. But in Iowa, you must change the wording in the power of attorney document to say that the agent can be paid for acting as a power of attorney, as a caregiver, and for care management activities. Then, to be 1,000% certain, you create a separate legal compensation agreement with the agent that includes the duties, the rates of payment, how they're going to be compensated, how taxes are going to be paid. And you do this to avoid the appearance of self-dealing or a conflict of interest, which can be considered fiduciary breaches and get you into a lot of trouble in court. And then in the Iowa Power of Attorney document and in the Colorado document, because I do recommend the legal compensation document also for Colorado, you want to mention that document in the original Power of Attorney document or in an addendum, because you do not want to end up in court during a parent's life or after a parent is dead and you're being sued because there was disagreement about you paying yourself and there not being an agreement. So for everyone, completing power of attorney documents is more complicated than you think. But as I mentioned, a lot of states, except for those that I previously mentioned, have the statutory power of attorney document information on their websites. And again, some states are better than others. Kudos to Colorado. Be wary of any vague information in any document that can result in the agent being accused of a breach of fiduciary duty. Parents, be aware of vague information that can cause you to be harmed. So, related to the previous mentioned topics of parents moving into an adult child's home, adult children moving into a parent's home, commingling money or property or bank accounts, or paying yourself to care for your parents, all these are major problems. They are a fiduciary breach of duty. Self-dealing, where a fiduciary profits personally at the beneficiary's expense. Failing to disclose competing personal interests, also known as having a conflict of interest. Number 3, specific to healthcare violating the duty of care and loyalty. This can include misusing confidential information and, to the previous story, hiding a dementia diagnosis and allowing a parent to drive behind the wheel of a car when it is known not to be safe to allow them to do this. So please do not place yourself in questionable situations when now you have the knowledge to take steps to know what can and might happen. Protect yourself by thoroughly understanding and reading any power of attorney document or really any legal document that you're going to sign. Ask experts what you should know about what can go wrong so that you can put safeguard principles into these documents. Just do not take them as face value. Do not just download them from the internet and sign them, because there's all kinds of unexpected things that can and will and do happen. And I know this because I'm Pamela D. Wilson. I'm a caregiving expert, expert witness, advocate, and speaker. I have 25 years of experience. My website is PamelaDWilson.com. I thank you all so much for listening to the Caring Generation podcast, episode 239. Please, before you go on with your day, like the show, follow the show. Please add a comment. Your comments, your follows, your likes help this podcast reach other listeners who are looking for expert help and support and advice around caregiving, health, healthcare, family relationships, and the legal and financial aspects that go with planning for care. If you want to find the show transcript with the link to the states that have that uniform power of attorney code, go to PamelaDWilson.com. Click on the Media tab, select The Caring Generation, scroll down to episode 239. That transcript will be up a couple of days from now. I thank you all so much for making time to be with me. I look forward to being with you again soon. God bless you all. Sleep well tonight, have a fabulous day tomorrow, and make every day the best until we're here together again.
Tune in each week for The Caring Generation with host Pamela D. Wilson. Come join the conversation and see how Pamela can provide solutions and peace of mind for everyone. Here on Pamela D. Wilson's The Caring Generation.